Thank you all for being here today. It's really lovely. I feel like we're having such good professional reunions. It's nice to see everyone just visiting and interacting with each other. But I'm so pleased to have the honor of moderating this panel and just so grateful that all of you made the trek out to Vermont to provide your expertise with us today. So I want to start with just a few statistics. So Indigenous people make up about 5% of the world's population, but there are many studies that show that they're safeguarding approximately 80% of the world's biodiversity. Here in the United States, there are 326 federally recognized tribes, and tribal reservations make up over 56 million acres in the United States, which is roughly 2.3% of the total landmass of the US. So taking into consideration the fact that ancestral territories are much larger than that, tribal nations are major players when it comes to public land management, water law, mineral rights, and yet federal Indian law is often treated as a distinct and separate discipline from environmental law when it comes to development of curricula and courses. So today, our panelists are going to share some advice on how to incorporate this knowledge into environmental law courses and discuss why it is important to do so in order to train the next generation of environmental law and Indian law advocates. So with that, I'm going to let each of them introduce themselves, and then we will have several rounds of questions. Nadine, we'll start off with you.
Sure. Hi, everybody. Thank you so much for having me today. It's really an honor to be on this panel with my friends and colleagues that I admire so much. My name is Nadine Padilla. I'm an assistant professor at the University of New Mexico School of Law. I just finished my second year, and I teach both in the clinic and in the classroom. I co-lead the Natural Resources and Environmental Law Clinic section, and I teach courses at the intersection of Indian law and environmental law, including Indian water law, tribal natural and cultural resources, environmental justice, and of course in the clinic. So it's been a great experience for me. To me, the study of natural resources and environmental law has always been very important to me. I spent about 10 years working as a community organizer in New Mexico in Navajo and Pueblo communities on sacred sites protection and working against uranium development on sacred sites in the area. And for me, it's very much a larger issue than just environmental issues. It's about our identities and who we are as Native people and protecting our lifeways, our ceremonies, our things that are culturally important to us. So that's what drove me to go to law school, practice in this area, and now teach in this area. Let me see, I think that's good for an introduction. Thank you for having me.
Yeah. Hi, everybody. I'm Vanessa Racehorse. I'm a member of the Shoshone-Bannock tribes, as well as a descendant of the Cherokee Nation and the Shoshone-Paiute tribes. I also was teaching with Nadine at the University of New Mexico School of Law for the past 2 years, but this August I'll be starting at Colorado Law School, teaching in the American Indian Law program. When I was at UNM, I taught a number of different courses in the Law and Indigenous Peoples program, from Indigenous Peoples and International Law. I just wrapped up a semester teaching Indian law, but all of my courses do have a segment that touches on something related to environmental law, like water rights, rights of nature laws. And I really was driven to incorporate information that's also relevant to my own tribes. So the Shoshone-Bannock tribes have a number of different environmental law cases. They have a number of Superfund sites sort of close to the reservation as well that implicate their treaty rights. So I also emphasize treaty rights a lot, which has a heavy correlation with environmental law and environmental justice issues as well. And I talk a lot about rights of nature laws in my research and scholarship as well. So thank you all for having me, and I'm excited to be on this panel.
And I'm Heather Tanana, so I'm a citizen of Navajo Nation. My father's side, my clans are the Kia'ani and Sinijini, so Tarring House and Black Streak woods people. Then Bill would say is Billigana on my mom's side. She's of European descent. And I was at University of Utah for several years with the Stegner Center in a research faculty position. And then last summer, moved out to Southern California, where I am currently at University of California, Irvine, doing a 2-year VAP. So I'm going on the market, finishing up that. It's been a really great experience and fascinating to see the differences in my kind of research role and then teaching role. I teach federal Indian law, but what I call tribal nations in the law. So I know we'll be talking a little bit about terminology and how that's shifted a little bit over the years, but I chose to call it tribal nations in the law. And I teach torts, which is another, for people who are following recent decisions, a really cool trespass one that came out of, the oil company and the big $500 million, I think, that the tribe was awarded for trespass. So Indian law, federal Indian law pops up everywhere in environmental issues. And I'll just, another big project that I also am still leading is this Universal Access to Clean Water initiative, which focuses on water insecurity out in tribal communities, accessing federal fundings, particularly with Bill and IRA, to help tribes fill the water gap, build infrastructure projects out there, do a lot of things out in Colorado River Basin. So I typically for the last 5 years have been very tribal water focused, but really love just the intersection of environmental, public health, federal Indian law. And I think for many of the Native law professors out there and Native attorneys, we got into this work because it's directly impacting our communities and we wanted to elevate the well-being of our communities. And so that is definitely underlying all the work I do and trying to get my students to, one, be aware of Native Americans in this country. I don't think many people, if you ask them how many federally recognized tribes are there, they wouldn't know. They wouldn't know that we just got a new one for the first time in Illinois that was recognized, right? They don't know what rights tribes have. So a lot of this is just basic history education as well. So yeah, and wonderful to be here. Could get to Gerald.
I'm Gerald Torres. I'm on the faculty of the Yale School of Environment, the Yale Law School. I teach the basic federal Indian law class, but I also, I'm not endeavoring to get fired, but I assume that there'll be pushback, because what I've tried to do is to originate a number of new courses related to Native issues, both at the law school and the School of Environment. So we started a clinic, basically tribal resource management, co-management clinic. So we run that, and that's out of the law school and the School of the Environment. We have an advanced federal Indian law class. We have a class on indigenous and tribal governance in the American Constitutional Order, which is a seminar, trying to look at the treatment of indigenous people in the Pacific primarily. And we had a class this last semester that was co-taught between Yale and the Salish Kootenai College. And so the graduate school, the timber management, that's what these slides are from. So we were trying to make linkages to a lot of the tribal colleges in order to address resource issues in a way that is effective. We also had there was a two-part, so it was a class with 12 students from Salish Kootenai, 12 students from Yale, and then the 2-hour class. The first hour was a webinar on the topic, and we had 3,700 people sign up for the webinar. So there's clearly an interest out there, and I don't think you can teach environmental law and not think about federal Indian law and tribal law. You just can't. Especially when you think about the way DOI is organized, right? They have public lands and people. That's who they regulate, right? Right. And in fact, there's a vast overlap, right? So if you do lands, and here I do forest stuff, interesting. But the reason I got into it was from living in Minnesota, where if you live in Minnesota, probably like New Mexico, but if you live in Minnesota, there's a tribal ethos that you can pick up, right? And so my friend Phil Fricky and I tried to identify all the Native lawyers in the country, and at the time we could identify 500. And so we said, we've got to, 500 is not enough, right? So what we started to do was to create opportunities for more Native people to go to law school, and now we're trying to replicate that in the natural resource area. So that's what I do. Water, of course, is a big factor. So that's what I do.
Great.
I haven't taught the basic environmental law course, I will say, in a really long time. I'm sure we all paid our dues, though.
Thank you, everyone. I realized that I failed to introduce myself at the beginning also. My name's Montoya Hammersley. I'm the director of the Environmental Justice Clinic here, and I'm a member of the Piramanso-Tiwa tribe, Pueblo tribe in New Mexico, and I'm also a Yaqui descendant. So really appreciate hearing from all of you the reasons why you came to this. I think what I really tell a lot of my students is that power and control over natural resources is at the root of so many things about how our legal system is structured, and federal Indian law is really at the root of so much of that. So it's really exciting to hear just all of the different areas that you all cover. You started to answer this question already, but I would love to continue talking about some of the other courses or areas of law that overlap with federal Indian law, perhaps some areas that people may not expect.
Okay, I'll go ahead and start if that's okay. So I like to say that Indian law is all-encompassing. It's arguably the most all-encompassing area of law because it touches on property law, environmental law, criminal law, family law, pretty much anything under the umbrella, any law school course that you've got going on, you could probably incorporate Indian law into it as well. So I've taught 7 or 8 different classes now, like Indian law, appellate advocacy, international law, and indigenous peoples, and American Indian children, youth, and families law as well. And as a practitioner, so I was practicing law for a couple of years before joining academia. I was just representing Native American tribes, and I really became a jack of all trades as well, which is why I was teaching a variety of different courses, because I've handled child welfare cases, I've worked on water law issues, I've done code development. So I do think that it's a really enriching experience for students to be able to explore these different topics through a different lens, and it sort of opens up this brand new world as well for them. I also didn't mention that I do teach tribal law, so that course in particular teaches students like just sort of I will say like a different paradigm and way to think about legal frameworks that go beyond just the Western legal framework, even though there are certainly parallels.
Yeah. Well, and the one thing I just want to make sure people were aware of, if they hadn't seen, because I know it went around the Indian law professor blog a ton, but that Dylan Heaton Nicely's at University of Idaho, and he put together, I want to say it was a couple of years ago, a whole series of webinars about how you can incorporate these Indian law cases into, I mean, it was like 10 different courses, obviously environmental, but like family and civ pro and property, because historically law schools, you had your one class if you had your one class, and it was all just in federal Indian law. And I think we need to normalize it more for students that you're talking about. Same way you want climate justice or environmental justice to not only be talked about in environmental classes, but in property, in contracts. We should be doing that as well with like indigenous peoples and their laws, and just making it more of an everyday conversation outside of viewing it as this niche area, because it's not. I mean, particularly if you're in the West, you're going to encounter this issue somewhere, and just having our students be better prepared for that, I think, can go a long way.
Yeah, I forgot to mention that I also teach a course on environmental justice and climate justice. It's one class, which of course intersects with a lot of these issues. But the seminar that I mentioned, Indigenous and Tribal Governance in the American Constitutional Order, that arose, and I don't know how many people do this, but I start my Indian law class not with the trilogy, but with the insular cases. Right, because what occurred to me is the insular cases were that moment in American legal imagination, right, when we kind of self-consciously became a colonial power. Okay, so a lot of what I've discovered is a lot of the statutes that are litigated in federal Indian law arose, put aside the treaty cases, but arose during that same period. When the Congress was clearly operating as a colonial governance. And so what I tried to do was to figure out, you know, what does the federal government think it's doing, right? And it gives you a new kind of insight into basically the colonial aspects of federal Indian law. Because you know if you read the insular cases, they're just an embarrassment, but they're still law. I mean, they're still law, right? I mean, like, who's the highest appellate court for Guam? Anybody have an idea? The Secretary of the Interior. And you say, wait a minute, I didn't realize he was an Article III officer, right? So, I mean, you get weird things like that develop, right? And so you want to ask, you know, why did this develop like this, right? What are the forces? And it gives you, for me, I don't know about anybody, but for me, it gives me a different insight into, you know, the statutes that were passed between, 1870 and 1935, probably, right? But what originally started it, right, was thinking about Native Hawaiians, right? Because Native Hawaiians and the Native people in the Southwest came under federal jurisdiction virtually at the same time, about 15 years difference, right? But of course, the Native people in the Southwest are Indians, right? But Native Hawaiians are not, right? And those legal categories matter, and they matter like for a lot of reasons. And so what I wanted to do was to explore that tension and that distinction. And then that, of course, carried me out to the rest of the Pacific. But then you're like in complete Alice in Wonderland, if it weren't too bitter and cruel. Anyway, I forgot. That's the way it intersects with federal issues that arise in federal Indian law. For me, intersect, as you said, with basically every class, right? And I don't teach any tribal law, just because I don't know enough to do it, right? So I'd like to, if you want to talk about teaching tribal law, here. There is a book, right? Matthew has his book, right?
Great.
I'll also just add that we, for my tribal, natural, and cultural resources class, we start out with a bit of constitutional law and looking at the First Amendment and the free exercise of religion as it relates to tribes trying to protect their sacred sites. And so just to point out the overlap in constitutional law, and that's where we, the Oak Flat issue that you might have heard of, that's a free exercise case when the Navajo Nation and community members were trying to protect the San Francisco Peaks in Arizona from a proposed ski resort. That was also a constitutional law case. So in that tribal, natural, and cultural resources, when we look at sacred sites protection, we're really starting with looking at the free exercise clause.
Thank you. So we use a lot of different terminology to describe what we do in the courses that we teach. I think it would be helpful if you all could give us some insight and maybe walk through some of the important distinctions in this field or important terminology that you use. I know I've had students this past semester who were a little concerned that maybe like saying federal Indian law or saying Indian was like an offensive terminology, and then having to walk them through that, Indian in the context of law as a legal term of arts. Maybe don't go around saying that to individual people, obviously, but here it has a specific purpose. Would you all be willing to speak to that?
Sure. Yeah, I mean, Vanessa and I were actually talking about this last night because like 15 years ago, we started the Indian law section of the Utah State Bar. They don't have one yet. We've got 8 federal tribes in the state, pretty good relations, a lot of ICWA work and others, but for their environmental work, a lot of the tribes were going out of state to Colorado firms, and we're like, we should try and keep this within the state. There's a lot of attorneys here, decent amount. There were like 5 native, attorneys. But anyway, so at the time we're trying to decide on the name, and we did not have Native Hawaiians or other indigenous group members engaged, and so we really are kind of actually even lower 48 kind of tribal member attorneys here, and so we decided to move ahead with Indian law section because that was the term used in the law and focusing on like federal Indian law. Anyway, flash forward, I think if we were deciding that name today and they're actually kind of debating whether to change it, we probably would have gone with a different term. I mean, one, because you want to grow and take advantage of partnerships and allyships with other indigenous groups, but also just, I think there's a movement starting that the younger generation does view Indian as offensive, or I'm not Indian. That's not what my dad would say. I'll be really clear about that. Or my grandparents are like, I'm an Indian, right? And this is the same way you get debates on like mascots. Some very strongly opposed to it, much more younger generation. Some of the older generation are like, I don't care about that, right? I don't see that as offensive. But we're seeing this change, and I think it's a momentum and movement to push along. And so that's why I called my course, instead of federal Indian law, I called it tribal nations, particularly because I also don't go much into Native Hawaiians or other populations. You can only cover so much in one course. But that was something I really kind of thought about, and how we can maybe, the next statutes, if you're engaging and trying to pass different laws, right, thinking about the terms, it's going to be a challenge, I think, because Indian is just pervasive in federal laws, but I mean, we have to change it somehow, right? We've done this with other groups. And I think that's kind of the movement I'm trying to move towards. And then, of course, the best is always to refer to the specific tribe, right? Dene or others. So when talking about cases, try to use who's the actual tribe we're talking about, and we refer to them by a tribal name.
See, I agree with that, but one of the things that students need to understand, right, is that even though it's a specific tribe that's in the litigation, the law is going to apply to all the tribes. Right, and so
Maybe.
Usually, right?
Yeah.
So
but that's a treaty, right?
I mean, Vine Deloria was giving a talk one time, and when he finished his lecture, a woman raised her hand and she wanted to ask a question, right? And she said, "Well, before I ask a question, I want to know how I should refer to you, right? Native American." American Indian, how should I refer to you? And Vine said, well, you look, Native American's fine. He said, in Indian country, we refer to each other as Indians. So that's fine too, right? He said, look, I'm just happy Columbus wasn't looking for turkey. And Vine could get away with it, right?
Yeah.
But now I will say another. When I got into the Justice Department, like the second day I was there, I got a 3-page, single-spaced letter from Vine, typed edge to edge, no margins. And it started out with, I know you don't know shit from Shinola about Indian law, so I'm going to tell you. And it was basically three pages of it. So
I hope you saved that letter.
Gerald, framed it.
It's in the Beinecke, so. It's pretty funny. It was like, okay.
I would just add, I can kind of see the terminology question from a mile away. So my first class every semester, I like throw up a slide on terminology and just the different terms that are used. And kind of always do a disclaimer of like, no one person is the expert on like proper terminology, what's politically correct. But I do sort of flag Indian as just a legal term of art that's incorporated and commonly used in Supreme Court cases, all the statutes that we're talking about. And that, each individual Native person is probably going to have a different perspective on the political correctness of that term. Although many of us do prefer to like identify by our own individual tribes, I would say that's a good rule of thumb. So helping students understand terminology right out of the gate when it's their first time being exposed to that, I think is super helpful. And I think it just sets the tone for the class as well to do that on the very first day. And I also flag Indigenous peoples as a global term of art, something that refers to, Indigenous peoples outside of the United States as well, with different terminology like Aboriginal peoples being utilized outside of the United States as well. So I think just as a practical point, that's what I like to do.
And I mean, the critical thing, right, is each of these terms is really fraught, right?
Yeah.
So like, under the declaration, right, there are no indigenous people in Africa, right? Because what they didn't want to do was to recognize indigenous people in Africa because the colonial powers in Africa, the colonial powers divided Africa up, right? Inconsistent with tribal areas. And they're afraid of challenges to the integrity of the nations, right? But you realize that's a huge omission, right? That's a huge omission, and there's got to be a way of talking about it, right? There's got to be a way of talking about the politics of those terms, right? And to me, you've got to be able to talk about colonialism and just kind of be frank about the world building vision that colonialism imposed, right? And not just here, right? But globally. And Zig, you had a question?
Oh, I have many questions. I have a nasty question, but I lived in Africa, and clearly the difference is they are indigenous, but they've taken power. They are the sovereigns, depending on the tribal mix in each of these invented nations. I worked for the Cherokee, and they said, don't call us Native Americans, that's a New York City term.
Right.
But indigenous, it seems to me, is a blanket term, and Indian can be thought of as a subset of indigenous, and maybe indigenous sounds better and travels better, I think.
Although, as my colleague said, it's a term of art, right? And so it's a legal term,
it's
right?
law.
Right. So, it's like you want to make sure, in my view, and you guys can disagree with me, but I want to make sure that I hold on to all of the things that attach to the idea of Indianness, right? Legally, right? I mean, if the Native Hawaiians were Indians, right, the litigation in Hawaii would look considerably different, right?
Yeah, it's a legal status.
Before I get to the nasty,
Thanks, Zig.
when you talked about free exercise, we lost the Sequoia case because the Sixth Circuit invented the test of centrality. We had shown that Chota was the Jerusalem of the Cherokees, but that wasn't enough to show centrality against the Tennessee Valley authorities. My clients call me White Rabbit. But the tough question is, I mean, I was working with the Eastern Band of Cherokee Indians, but Oklahoma showed that when Mia started off, she was talking about 80% of the resources are, did you say? They are shepherded, they are
Safeguarded, I think.
Well, but the trouble, and Murray Rankin's a friend who just in Canada has negotiated really a governance role for the indigenous people that gives them a veto. But the problem is, there's a tremendous pressure to sell out. And in Alaska, we've had that. We've had it in other places where the fossil fuel industry comes in and gets the tribal council it wants, and then, or I suppose uranium dumping. There is the temptation for native indigenous governance to sell out resources, which makes them sacrifice areas in some areas, or potentially sacrifice areas. So it's not enough to think of native peoples as guardians when you recognize that that can so easily be perverted by the pressures of capital. And it seems to me that that is not going to go away when we talk about rights of nature and things. Although all I know about the Navajo is Tony Hillerman, but I didn't see that tension much. Oops, all right.
Oops.
I now pass on.
Nadine can correct you.
I'll speak to that and then I'll pass it to Nadine. I think this is definitely something that's come up in my environmental justice work, and a stance that I've taken in my personal practice and now with my clinical students also is, at the end of the day, the environmental community has to decide whether or not it respects tribal sovereignty. And I think something that I teach when I talk about Indigenous environmental justice, as Rebecca Sosi discusses and talks about in many of her articles, is tribal sovereignty is an aspect of Indigenous environmental justice. It's important that tribes have the right to decide how to use their resources. And sometimes that might look like fossil fuel development. It depends on their particular situation, their resources, what their people need at that particular time. So I agree that I think it's, inaccurate to think of tribes only as guardians of resources, but I also think that part of federal Indian law, and for those of us who do, at the end of the day, believe in self-determination, that it's important to respect those decisions of tribal governments as well, the same way, because they have the right to use resources in the same way that any other government does. And overwhelmingly, even with those choices, they are still protecting large swaths of biodiversity as compared to much larger governments across the world. So I think it's definitely something to continue to discuss. But
yeah, thank you, Mia, for providing that. I think the tension that you point out is a real thing that people in communities and tribal governments have to figure out how they want to handle. And I think tribal communities have been put in a position where oftentimes we live in poverty conditions, maybe no water, no electricity, no grocery stores within an hour's drive. I mean, people are really making hard choices, and it can be very tempting, I think, for some communities once you have a company come in and kind of throwing money around and giving your kids scholarships and giving out meals during holidays so that you and your families can have something to eat. It's a very real tension that exists, but I also think it is up to the tribe, it's up to the communities on what types of economic development they want to pursue.
Yeah, I mean, you compare fracking state to state. You see the same, outside of the tribal context, you see the same kinds of economic pressures that are being put. I mean, Pennsylvania, right? I mean, fracking is basically unregulated, right? And so it's hard for farmers who are just scraping by to turn down that check, right? And tribes, face the same kind of economic pressures that are a consequence of the historical position that colonialism has produced, right? And that's important to recognize. But I mean, to the extent that I think there is an obligation to my friend Pat Rogers says, what sovereignty means is the power and freedom to make mistakes, right? And so the tribal government, you don't have to agree with the tribal governments, right? But you have to respect their capacity and rights to make decisions for the people.
Could I just add, one of the things I mentioned was corruption, where there's secret purchase of, and this isn't of course just in one community, it's everywhere, but it is particularly difficult if there's this source of money and pressure and media and to subvert the decision-making of the tribal sovereignty. And it's very hard for the people in a tribal community, first of all, to know about it and to counteract it. I'm sorry, I'm being dismal, but it's a real problem in every society, but it seems to me some societies may be more vulnerable to the pressures. In Africa, we saw constantly, my friends were saying, we have to find a way to reform the pressure of corruption, which just creeps under the door.
I think this question relevant to the complexities of modern Indian land use actually comes up a lot in my classes, because I think students are actually quite measured in terms of not romanticizing tribal nations in any way, shape, or form. But I do think we talk a lot about how tribal governments aren't that, I mean, they're just people. They're not that different from state governments and federal governments as well, which choose to tap into natural resources for economic development. And I don't know if, these economic pressures make them any more, say, vulnerable or susceptible to outside influences, but it's just, I think, a good indicator of how they are just people and they are governments that make these same choices that state and federal governments are also quite pressured to make as well.
Yeah, I think what it brings up for me more so is the role of the federal government historically, right? And how they took away the ability of tribes to govern their lands. And even now in the energy world, right, all of the different oversights and approvals and, our big COBOL case we talk about and all of the trust cases. And if the federal government had just done its job and upheld the treaty trust responsibility, looked out for tribal communities instead of energy development off lands, they wouldn't be in this situation. And even now we're still, I think the current administration has come a long way to kind of fixing some of these historical injustices and changing the dynamics between the feds and tribes, but we're still not there quite yet. And so when we talk about corruption, I'm like, I'm trying not to stare at Cliff. I'm still like looking at the agencies, being like, how are you haven't given back the control. And they've gotten there, don't get me wrong, all the co-management stuff is amazing, but like, what are you doing right now? I'm more worried about what the federal government is doing, less so than what like the tribal council is doing. And the other balance I think we're also seeing more is the local, and again, most of my experience was Navajo, but a lot of local advocacy groups within the tribal community that's holding the councils accountable, right? Like the Navajo, the proposed hydro storage pump project out in Black Mesa that FERC denied the permit for, a lot of that was driven by Tuonajoniani, this local grassroots organization going out and doing educating and opposing it, that they got the council to formally oppose it as well, and then FERC denied the permit without tribal community agreement. So, yeah, I don't know. Those are the two things that came to my mind.
Can I ask a rights of nature question for you?
Sure.
I followed the Manuman?
Yeah.
Right?
Yeah.
And I was interested to see the tribal court decided not to recognize the right of personhood. What do you think is the potential for tribal courts to develop some of these new areas of the law? What do you think about that?
Yeah, okay, is it okay if I
Yes.
Oh, perfect. So yeah, that tribal court decision was really fascinating, and it just hinged on a Montana question. For those of you who are familiar, Montana is a landmark case that I think really constrained tribal jurisdiction in specific ways, particularly like, say, regulatory jurisdiction, enforcement of these rights of nature laws. there, I think it really hinged on the enforcement of like off-reservation activity over, these non-Indian actors. And I sort of argued that maybe it could be cabined in that way. Maybe there's still opportunity for the enforcement of rights of nature laws like on reservation. It's a very like specific set of facts in the Manuman case. So I think that there are a lot of unanswered questions there for what that could mean for other tribal laws, other tribal courts that will be sort of looking at the exact same issue. The Sauk-Suiattle tribe as well had a sort of rights of salmon law that they tried to enforce, and that resulted in a settlement. So they didn't actually answer the question of whether or not that tribal law could be enforced in tribal court because it just settled and they got the outcome. Hopefully they want it. I haven't looked at what's happened in the past month or so, but I do think that there's still a huge gateway that's open for tribes to enact rights of nature laws, to sort of exercise their sovereignty in this new sort of path marking way. And then let the tribal courts decide these jurisdictional questions, which are really complex, because I do think that people assume that the tribal court is just going to automatically say that the tribe can enforce its laws. But there we saw White Earth's tribal court said we're constrained by Montana case law here. Just sort of showing how measured and deliberate they are in their decision-making process. But other tribal courts may be grappling with different fact patterns when making these jurisdictional decisions.
What should we be watching? Any particular issues, controversies?
Any particular controversies? I think the Sauk-Suiattle one, I still sort of ongoing in terms of the settlement and what's going to happen there. And I do think I've seen some student scholarship come out about that, which is really interesting and sort of revolutionary in certain ways, but I do think a growing number of tribes are adopting these rights of nature laws. So seeing what they do and the impact of that, I think is going to be really
And if I may, there's one other case that intrigues me, and that's the Bad River
I haven't heard of that
Reservation
one.
and the Enbridge trespass and what is supposed to happen, because the tribe not only wants, justifiably, the line off their reservation, they want the line out of the watershed. So I don't know if you're following that one, but that's intriguing. There's a treaty with Canada that our friend Senator Stevens gave us, guaranteeing the right to run pipelines for gas across Canada into the United States. Guess from where? And so you have a juxtaposition of, as I understand it, a treaty that governs some of the rights the tribe is asserting, versus this other treaty between the United States and Canada that's supposed to be subject to arbitration. So when you talk about indigenous law, tribal law, the Indian law cutting across everything, it sure does. And the court and the Justice Department came in and said, well, you're both right. The tribe, you're right. There's a trespass, clearly, not only that should stop, but also should be compensated substantially more than what the lower court found. But on the other hand, there's this other treaty thing here that we have with Canada, so we're going to have to navigate between our trust rights to the tribe and our international obligations to our good friends to the north. I don't know what all this means, but it's interesting stuff.
Yeah, that is a great segue to my next question,
Yeah.
Pat. Thank you so much.
That's what I did.
So Vanessa's already given us some of this information, but can you provide some examples of maybe some recent case law that you would recommend incorporating into environmental courses? I know, Heather, if you want to start.
Well, I just love the Arizona. The outcome was not great. Yeah. The Arizona versus Navajo Nation from last summer, but there's so many issues that it relates to that it makes it a really rich case to talk about, of what was in the background when that case went before the Supreme Court, right? The nation was saying, we're not asking to quantify our water rights. We just want the federal assistance in order to assess our needs, right? Like that number one beginning step to take development, to be able to seek grants for infrastructure. And when we look at the difference between like shovel-worthy and shovel-ready projects, because the bill money that's out there, it's funding the shovel-ready projects because they're ready to go. The administration wants to, get it out on the ground. That's easiest, but we're overlooking all of those shovel-worthy projects that don't have the environmental assessment or an engineering assessment done yet. And so for me, the relief Navajo was asking for was that preliminary step to be able to one day bring in the infrastructure pipelines in whatever way. Maybe the feds help with it, maybe the nation does it, whatever way. And I think it was all of the things in the background about aridification and climate change and, the basin already being over appropriated and this fear of what's that going to do for Colorado River Basin management, that even though the justices didn't directly address it, you heard it kind of pop up a little bit in some of their thinking. So again, I just think it's a rich case to talk about, sure, kind of federal treaty trust responsibility. And I think there's a difference there. The cases where the tribe tends to prevail, the court takes the time to go through really in depth on the history. And when, this opinion was like, 7 pages? If they don't go into that depth, you're kind of like, uh-oh, they didn't get it or are disregarding it. But it also, I think, is another way I liked with my students to bring up, and really any recent Supreme Court case you could do this with, but the Tribal Supreme Court project that NARF and NCAI does, because then you can talk a little bit about the, because like Gerald said, many decisions uniformly get applied to all the tribes, and so there's this concerted effort to be thoughtful and strategic in the cases that were being brought that could appear before the Supreme Court, and coordinating the amicus briefs. And so I was part of one brief representing Dig Deep and really focusing on the water and security. Other ones touched on historic or trust responsibility. And so that too, I think it's worth it to talk about that project and pull up some of the amicus briefs so you can see how it's this coordinated effort that happens now. That's pretty cool.
Yeah, I like teaching the treaty cases out of Washington, right? Especially the Culver's case, right? Because what that for me, what that sets up, right, is the extent to which there are affirmative duties that are imposed or potentially imposable on the state that grow out of the treaty between the federal government and the tribe. And then you get to talk about things like ecosystem services off res, right, which have an impact, have an impact on the resources on the res, and how are you going to incorporate that in the decision-making process? And is the tribe situated to raise those issues, right? And what administrative process should, given the treaty rights, should the tribes have access to and be party to? So those are the cases I like to teach. But yeah, the Arizona case, the Supreme Court's deciding more Indian law cases than it ought to.
Terrifying.
Right.
Yeah.
Right. So you could do the Brackeen, right? And which is an Indian Child Welfare Act case, right? And slice that any number of ways. And or the Oak Flats case, right?
You might say a couple more words about the Culver case. I'm not sure everybody.
Praise God, it was an evenly divided Supreme Court, and so it upheld it. So it's basically, had the appointment been through, we would have lost. Right? But the federal government and the tribes were suing the state of Oregon to remove or replace or fix the culverts that interfered with salmon being able to get back to their spawning grounds. And, you know, if you look at photographs, you can see that the culverts clearly are a barrier, right? The state's defense initially was, we built these with federal money consistent with federal rules, right? So the federal government can't be now telling us that we did everything wrong. This is not a terrible argument, right? But the question is what are the treaty rights that the tribe has? And can the federal government, in service of those trust and treaty rights, right, impose this additional obligation on the state? And the answer is yes, right? But you know, the amazing thing is, right, the state of Washington made the argument, right, that the treaty only guaranteed the right to fish. It didn't guarantee any fish.
Yeah.
Right.
That's the second half of Bolts.
Right.
Yeah.
And there's that wonderful, question by Justice Sotomayor inquiring whether they really wanted to persist with that argument, right? You could feel the bug in the squash. I mean, it's an absurd argument. The idea that they thought they could make that argument is what is appalling to me. It's like the free exercise cases. Some of the arguments they make in those, like, if you made these in any other religious context, like, you'd be beaten.
Yeah.
Right?
Yeah. Well, in Arizona, you have the right to water, but we don't have to help you get that water.
Right. We don't even have to tell you how much you're actually.
Yeah.
Who's using it? Yeah. Right to water. Hey, how much? Well, don't worry about it. Right? It's like.
Yeah.
Whatever's left.
Right.
Yeah.
Well, I mean, because your discussion of the case is exactly right. It's like, Kavanaugh goes off on this toot.
Oh, yeah.
Right? And you're saying, Brad, nobody was talking about that.
Have a
was talking
beer.
about that. Right? We were talking about, like, the first decision that has to be made, which is how much water is the tribe entitled to? Nobody's talking about building a pump, building a dam, building a pipe. It's like, but he goes off on this complete toot. It's like, you're thinking, like, which lobbyist wrote that opinion? That's what I'm thinking. That's unkind.
Probably
You can
someone
edit
from
that.
Arizona, but I would imagine.
I had one more
Go ahead.
case, and this is an older case from the 10th Circuit, and you all are probably familiar, but Albuquerque v. Browner is a really great case to incorporate into your Clean Water Act discussions. That case looks at the Pueblo of Isleta's TAS status and their ability to set and enforce their own water quality standards. And in that case, the Pueblo was successful in holding the city of Albuquerque accountable in meeting those standards. The city of Albuquerque had to build a huge, very expensive water treatment plant in order to clean the water to standards that would meet the Pueblo of Isleta's water quality standards. So that's a really great case to incorporate, and the opinion is really great. It talks a lot about the Pueblo's uses of water, which includes cultural and traditional uses, and it's a great case
It's
to
a
look
great
at.
case,
Yeah.
I love that case too.
Yeah.
It's on law and
Yes.
environmental,
Right.
because the city of Albuquerque actually challenges this as a violation of church and state, and the court says, no, it's not, it's about protecting human health. And what I also love, and you may be surprised, is that the court says, and how the tribe chooses to engage in its ceremonial practice is really none of your business. That's what they do. For EPA, it was really just about accepting that the tribe had established this is what they need in order to continue in their cultural engagement, and that's enough, and it should be enough. And so I love citing that case every time I get a chance, because some things just aren't my business. We just need to take, this is the tribe's value, this is the thing that we're here to protect.
Can I
Thank
add
you
one
for-
more?
Yes, of course.
So pending in the Ninth Circuit right now is Shoshone Bannock Tribes v. Interior. And that's all about the Black Rock land exchange that Simplot is trying to get so they can expand their gyp stacks. And it's already a super fun site. So I think that's a really good study of treaties as well, because the tribe's treaty rights are at issue, their use of fructuary rights on this land, because it is their ancestral homelands, are at issue, and it's a good discussion of the trust responsibility as well. So it's like exposure to all these fundamental components of Indian law with these environmental law issues as well.
The Dan Sisters case, which you can teach from the Inter-American Court, right? You don't have to teach the federal court case, right? Because they took it before the Inter-American Commission on Human Rights and raised an issue about payments from the federal government and the way the federal government was characterizing the payments. So that's an interesting case, but you can approach it from an international law perspective. In international law as well, the Agostini case out of Nicaragua is really interesting, because there the government of Nicaragua gave a timber concession to Japan. Right, and the Agostini community said, not so fast, that's not your timber to give away, right? And so the case goes through this long basic proof of a property interest of the Agostini community in that territory. And what they discovered, of course, is that many native communities had claims to that same land. And so what ultimately got resolved was, look, there are lots of ways in which claims can be legitimate even if they don't conform to the kind of fee simple idea of ownership. And the Agostini community, prevailed. So it problematizes property, the procedure, right? But Judith Resnick's federal courts book also has Indian law cases in it.
That's great. And then,
Yeah.
Oh, go ahead, Fred.
Can I add something? I think so. Also another case. I'm Fred. I'm from the Maasai tribe in Tanzania, and this
A
one
little
case.
louder.
Yes. My name is Fred. I'm from Tanzania, and I'm from an indigenous tribe, the Maasai tribe in Tanzania, and my family is from the Ngorongoro Conservation Area. I think so. One case that has been ongoing, particular case study in the international field, is the displacement of the Maasai people from both the Loliondo area and the Ngorongoro Conservation Area to pave way for tourism plus conservation. So I think that's something that we need to keep an eye to. And but the other thing too is also like really same as indigenous tribe, what they're going through here is just like good to keep in mind that the structural and power imbalance that is happening domestically here and also back home in Tanzania, which is a big problem. Whereas we own land as a collective right, we're not tied into the property, the way the US regulate land and property ownership individually, so we own land as a common resource. But conservation, tourism, that economic pressure that we're talking about is having a huge impact, because that area generates a lot of tourism money, plus conservation too. So what ends up doing is displacing our community from their ancestral lands, from their homelands, somewhere else, apparently like 330 miles away from their ancestral lands, which is a long route. But it's yes, alluded that corruption is one thing in Africa, but also let's keep in mind the structural imbalance, because if the structural imbalance is there, the communities themselves, even if they want to oppose a particular displacement or a particular economic pressure that is coming on their way, they're not able to do so because of that structural imbalance. But secondly, too, is that it's not always about just the economic pressures, but it's also about the conservation pressures also, which exist and persist because of the historical context of the establishment of those areas, such as the Serengeti National Park, the Ngorongoro, which is a whole World Heritage Site. So those international pressures also plays a role in the displacement of people in those areas, not only displacing them, but also like extremely highly regulating communities and indigenous communities living in those specific areas. So for instance, as an example, we don't learn as a collective right that you're not allowed to dig the ground and grow maize or beans for subsistence. That's prohibited. And it's still your land, still, the government highly regulates it, but we just have to take that into account. And also, historical context plays a huge role in just understanding communities. Thank you.
Thank you, Fred.
Can I ask a question?
Of course, yes.
I'm still thinking about your comment, Zig, about tribes and, temptation, particularly economic incentives. From a bit of a, New Mexico, but observation, I think it's pretty remarkable that there have been multiple generations of proposals for high-level radioactive waste disposal in New Mexico. And yet, none of them have gotten through. Noah Sachs wrote an article, I just looked up, I remember it was 1996, where he wrote about 20 years of history trying to cite high-level radioactive waste disposal in Mexico. And it hadn't happened by 96, and it still hasn't happened by, God, we're living in 2024, I feel like we're in the future. So, on the one hand, while there's all this temptation, it hasn't actually happened, that hasn't happened. And there's still proposals now for monitored, retrievable, high-level radioactive waste disposal, and that still hasn't gone anywhere. But I'm just wondering, because, law professors love a hypothetical, what if there was a tribal council that said, let's do it, bring in $1 billion of economic development and schools and jobs, and you had a strong vocal minority that said no. And there are those tribal organizations, Dene Care, but others might be one who would challenge that. I'm just wondering what, what the panel would think. Like, how do you navigate that? Do you represent the tribe and tribal sovereignty? Do you represent the people who might have a strong and valid objection? And sort of what would be the role of good ethical lawyers in that space? Anyone
It's
dare?
quite the hypothetical, Cliff.
Yeah.
Thank you.
Who are we representing in this hypothetical?
I think we have to decide, right?
Well,
So-
that
Imagine there's voice on both sides.
hypothetical arose, right? I'm blanking on the New Mexican tribe that agreed to take waste, basically.
Toxics. Toxics.
Yeah, it was actually radioactive
Oh, okay.
waste. But then there was opposition, and the decision, basically the people objected and got the government to, flip its decision, the tribal government, right? So, I don't know about y'all, but I have like this basic rule, which is probably not a good rule, but it's the rule I apply to myself, and that is I don't sue tribes.
Yeah,
Yeah.
same. Yeah.
It's like and not because every tribe is noble and every tribe is good and every tribe is on the right side. It's like, I represent individual tribal members on various things, right? And sometimes within like a tribal legal context, not in the state or fed, right? Administrative context primarily, right? But by and large, that's the rule I apply. It's like,
Yeah.
Would you represent the tribe in defending a challenge of the tribe to bring the high-level hazardous waste to their?
would I?
Are you just trying to get us on record, Pat, with these questions?
If they were my client, right? If they were my
That's why I asked
client,
the
if they were my
question.
client, there's certain.
Would you take the case, I guess?
No, probably I wouldn't take a case if
Yeah.
I didn't have to, right?
Mhm.
I mean, that's the chicken
Yeah.
answer. I recognize.
Yeah.
But you could avoid a fight perhaps by saying, this is a pissing contest, we have to listen to our people.
Right.
Otherwise our government becomes illegitimate, or some conversation like that. Even when you're representing a tribe, you can say things like
Well,
that
well,
behind the door.
Yeah, I mean, there is, within the broad ambit of client counseling, right? There are
If you're
many-
asked.
Yeah, if you're asked,
If you're asked.
you can discuss that, right?
Ask me this and I would tell you.
But, you know, it's like, yeah, I mean, it's like, I agree with Pat, right? If you're asked, you can talk about it, but.
Yeah.
But if you project that, watch out. You are running into a real tension area of client relationships and
Oh, yeah.
client loyalty, and you really, I've
Yeah.
been in that room, so it's not an easy one to navigate.
I mean, there's the one issue of like, internal disputes of like tribal community members against their tribal leadership, and there's a process there, right? I mean, we get all these lawsuits where you might have a turnover in tribal council, and they disagree about who leads, frequently asking Fed courts to make the decision, and Fed courts are always saying no. That's an internal tribal dispute, it's up to you to manage it. And so that to me seems like what it is, an internal kind of dispute. What's interesting is with ELI, they reached out when I was at Utah, and they were trying to compile cases, and we're looking for cases where a tribal member had sued in their tribal court, the tribal government, for lack of environmental protections. And Elizabeth Cronk-Warner and I were talking about this, and we couldn't think of any case where that had actually happened, that we were aware of within our communities, and then certainly searching online about the few cases, tribal cases that are on like Lexis or Westlaw, they couldn't find any. So it's a really interesting, I think in the future, it'll be very interesting if we see, like Danae Care, others, when they feel like their tribal government isn't being protective, taking action against them. But I still think the dynamic is too much where the federal government is controlling a lot of it. They're the ones you go after right now, not the tribe.
Yeah, I mean, I was involved in a suit representing tribal members against the interests of the tribe, but we were suing Interior.
Yeah.
Yeah, I think.
A lot of DAK versus BLM or.
Yeah.
Right. And,
DIA.
and
I'm sorry, I have to go set up next door. And if anyone wants to know about having environmental law being taught by law students with faculty status before they graduate, Lee will be glad to talk to them.
Oh, that'd be great.
Got some flags.
Are you offering cookies? or
Heather,
what?
before I forget, how about the blue lake?
By the way, did you notice nobody mentioned
Wasn't
administrative
that
law?
the tribal members
Towards
suing
property,
the
but
tribal
administrative
government?
law
Administrative law.
at the heart of it.
Yeah.
Well, there-
Or follow up, see if they compiled anything. It was a couple of years, I want to say like, at this point, probably like pre-pandemic, so 4 or 5, when was that, 5 years ago? ELI was looking at doing that project.
Yeah, I'm not
They
sure
were
if it's,
That's what I was saying,
Exactly.
to follow up and see, yeah.
Well, there are 2 more questions that I would really love to get through before, and I want to give you all a break before the next panel as well. So, 2 ethics-related questions, which I think are really important to teaching in this area, and we've already touched on quite a bit in our discussion so far. So, obviously, teaching federal Indian law in particular and a lot of related tribal law courses involve teaching students about often a very traumatic history and things that can be difficult to talk about. So I'd love to hear from you all how you help your students navigate that, and also how you incorporate teaching of cultural competency into your classes.
I can go first. I think it is really tricky to teach, and I think it can be uncomfortable for Native students as well as non-Native students. And I approach these conversations by just trying to create an open and respectful space and hopefully set the tone for my class so that we can trust each other to engage in those conversations. I also would say don't shy away from it. You have to say it, you have to bring it up. A lot of times you have to quote our Supreme Court and read those really offensive, the offensive language and terms that they use. But I've been fortunate, I think, to have really great students who are really kind and respectful to one another as we have those conversations. But it can be tricky. And thinking to my environmental justice class, when we are discussing kind of hot topic issues or issues where there's a lot of debate on both sides, I always like to ask students to kind of debate both sides. And I feel like that helps take maybe it takes a spotlight off of the student and they're advocating for ideas and thoughts versus maybe where their own personal opinions lie. So that's been helpful for me.
That's really great. I will build off this concept of not shying away from it, because I'll often, when having to read like highly racially charged language that is very offensive, I'll just acknowledge like the law can be really racist and the law can be really unjust, but this is still good law that's on the books. These are, foundational Indian law cases that refer to Native people in really inappropriate ways, but it sort of informs our understanding of the Supreme Court's decision-making process and where they're going and the lens that they're applying. So I do think I try to just address it head on. And it is really uncomfortable. I don't think there is like a solution to like alleviate that discomfort, but acknowledging it and creating space for students to like talk through it. And I've also been fortunate enough to have students themselves that will like engage in that dialogue and talk about how problematic it is, or sort of deconstruct it and critique it in their own ways. I actually like kind of borrow a lot of language from them each semester where I was like, ooh, I'm gonna use that next time. Next time I teach that. So I think like creating that space for students and sort of acknowledging the problematic nature of it, even in like Johnson v. McIntosh, spending time talking about how problematic that decision making is and how frankly racist it is, opens up the sort of dialogue in a way that I think can be really helpful in understanding our legal framework.
I mean, I guess I'd say I spend a lot of, like, my goal in Tribal Nations course at the end is, really that they come away understanding how we got to the inequities that tribes face and that historical context. And because that, I think, is the hardest to grasp. The law, you can Google it later, you can pull that up, right? You're going to get a case, you'll research it. But for me, it's really having that understanding of what tribes and Native people in this country have gone through, so that when you go to the reservation and you look around, you can, understand why it looks the way it does. Because it's shocking, right? When you are in somewhere like DC and then next you're in Window Rock, and they don't look the same, and they don't look the same for a reason because of those federal policies. So I spent a lot of time going through the history and why some of the cases are so long, because they talk about that history and emphasizing why that's important. And then I share a lot of my personal family history as well, and bring in guest speakers from the community so that it grounds it and makes it real. And I can say, yeah, I've lost relatives to diabetes, right? My aunt, she couldn't make it to dialysis because the drive was 5 hours one way. You get, as when she had that amputation, that was like a death sentence for her. Like, that's the reality. And so for me, being able to connect with my students that way, and just trying, if I can get one of them to care, that to me is the win. Because then when they have that opportunity, because face it, tribes are still building back their capacity. We have to rely on outside individuals to assist in a lot of situations. If I can have my students who care and understand that history, I think they'll be a much stronger advocate.
Yeah, I think spending some time on the history is important. In the class we taught with Salish Kootenai, and I, we had a lot of guest speakers come, and because not all the students in the class are from the Salish Kootenai tribe, they objected to some of they're all native speakers that we had bring in forest management, but they were discussing managing certain plants. And for some of the students in class, it was like, they can't even talk about those plants, right? It's like, we don't, right? And so the question was, what do we say to the presenter, right? Because it didn't affect all of the students, right? It only applied to some. And it directly went to that particular tribal management of that area, right? So those are kind of tricky problems, right? And that was hard, right? The only other time it ever came up for me was when a student in my property class objected to me teaching the Indian law classes, Indian law cases, right? Because, God damn it, we beat them in a war, and damn it, we shouldn't have to account for anything, right? This is when I was teaching in Texas, so.
We stole it fair and square.
No, my response was very plain. I said, for somebody sitting in Austin, Texas, that's a really peculiar argument to make. You sure you want to stick with that one?
It's not a by our question.
Exactly. Exactly. It's like, really? A little self-reflection would work here. Anyway, there's another question you wanted to ask. I'm sorry. I shouldn't tell jokes.
It wouldn't be an Indian law panel without jokes, so we're just. No, I think I want to give you all at least a 10-minute break before the next panel. So maybe if any of you have just closing thoughts on why it's important in general. I know we've spent a lot of time talking about this, but why it's important in general to incorporate federal Indian law into environmental law curricula.
I mean, I think teaching the kind of the decisional structure and the use of canons and things like that in federal Indian law, and to ask how it impacts things like administrative law, I think are really critical, as well as teaching things like tribes of state status. But it's the jurisdictional questions are always the ones that are most complex. I was thinking you were talking about rights of nature, right? The Penobscot River is now a citizen of the Penobscot Nation.
Yeah.
Right. So the Penobscot River should have standing.
Yeah.
Right.
And maybe the Penobscot River is liable when somebody drowns.
Right. Maybe. Yeah. So we don't know. But we have Ecuador, we have New Zealand, who have also adopted these things. What can we learn from them, right? So I mean, I think it just if you look at the way the legal treatment of Native people historically has evolved, it opens up every significant question that the law addresses, period.
Yeah. Yeah, I mean, in building off of that, like how Gerald was saying, looking to other communities, learning lessons, like tribes today, particularly in the basin, I mean, it's recognized average 25% of the river's flows are tribal rights, and then there's a whole, I think 11 outstanding claims, probably gonna drop after Arizona settlement gets done there to, I don't know, 8 or so, but they're big players in this field now. They can be big players in the renewable energy, right, in water law and climate responses, and so it's a missed opportunity if next generation of attorneys is not familiar with those opportunities to respond to climate and forge partnerships. Again, you gotta be a little careful of not being too extractive, right? Because sometimes I feel like this goes to engagement. People come and I want to partner with you, and don't be offended if they're like, thanks, but no thanks. I don't want to partner with you, right?
Yeah.
But that's, again, the history. That's a natural reaction because they've been exploited, and just, kind of now as we're going into traditional knowledges, I think, again, so much to be learned, so much that they can do, but we need to do that in a way that's not exploiting them again, benefiting everybody else except the tribes themselves.
Yeah, I think that's a fantastic point. I do think that incorporating this information into the law school curriculum is a great opportunity in order to sort of expand students' worldviews about what the law not only is, but what it could be. Because there's so much diversity within tribal communities and what they're doing within their own legal frameworks. So I do think students get really excited about it, where they're like, wait, this is a different way of approaching the law or enacting laws, or, what direction could it go? Always being mindful that, tribes are to be like treated as important stakeholders, not just, objects of study. So we're not trying to be extractive in any way, shape, or form. But I do think that incorporating this into the environmental law curriculum also pulls together these different pieces and concepts because it's so all-encompassing. So we're learning about, Fed courts, learning about the interactions between the federal government, the state government, and tribes, while also studying these like core sort of environmental law concepts. So.
And I'll just add, oops, the PowerPoint is going.
No, I just wanted to flip to the next slide so that just for forest management, these are all the federal statutes like you have to pay attention to, right? And so it's like, it cuts across, and all manner of things. And when you start to do like range protection, right, or animal protection, it's like.
Yeah, just to add on to that, I think it's really important because when we bring in federal Indian law, we're really telling the story about people, and we're bringing in that human story and how environmental issues impact tribal communities on every level, from cultural sites, sacred sites, to reproductive justice and physical ailments that people are having. For me, it's just important to kind of put a face to all of these environmental laws that we study so that people will remember when they leave law school.
Well, thank you everyone for this robust discussion. Just give a round of applause for our panel.